Being sued by a debt collector in 2025. I'm here with John Skiba with Consumer Warrior. What do you do first?
Well, I mean, what people are not I mean, the debt collection industry and the lawsuits that they're filed by debt collectors, it's gigantic. And even as a practicing attorney early on, I didn't realize what a huge impact it plays in people's lives and even in the court system. Here in Arizona, where I practice, other than speeding and criminal type offenses, these debt collection lawsuits are top of the list as far as what clog up the dockets of the courts. The biggest debt buyers in the nation, if people are dealing with debt, they probably recognize names like LVNV Funding, Resurgent Capital, Portfolio Recovery, Midland, all those types of companies. They, on average, file about 500,000 lawsuits a year nationwide, each of them. And so it's just gigantic volume that they're dealing in. And, the number one thing that concerns me, and when I started really getting into this area of practice 20 years ago,
Yeah.
is there was a national study done that showed that over 95% of people who are sued don't respond to it. They end up with a default judgment.
Yeah.
And if the judgment gets entered, it's kind of game over at that point. And that often leads to different bankruptcy options that we have to look at because there's no real way to defend it. But I have found if people do take action, and we can kind of dive into what that looks like, but just participating in the process, it gives them at least options. Bankruptcy is still an option that can deal with this, and it's kind of our nuclear option that gets rid of everything.
Right.
But there's also other options you have for settlement and even contesting the lawsuit that, may make it so that you can get out of this without having to take those different steps.
So 95% don't even respond. And when you don't respond to a lawsuit and you get what we're talking about, a default judgment, that's where the debt collector can go garnish your wages or whatever that and those next steps are. That means you have no recourse, right?
Yeah, I mean, the whole purpose of why the debt collector wants to file the suit is unsecured creditors where there's no collateral or property attached to it. They're usually the loudest and the most annoying because that's really all they have until they sue you. And once they sue you and get that judgment against you, that's their hammer. That's where they can come in, garnish wages, garnish bank accounts. They can record it and it acts as a lien against your home. And so they can cause all kinds of havoc with that. And the other issue with the default judgment, if you don't respond to these debt collection lawsuits, it's something where, this a $5,000 credit card lawsuit, all of a sudden they're adding pre-judgment interest, post-judgment interest, attorney's fees. I routinely see those at $8,000 to $10,000. They jump up,
Yeah.
and then they sit there and churn interest for years. In Arizona, again, where I'm at, civil judgments are good for 10 years, and then they can be renewed every 10 years for the rest of your life. And
Gosh.
I see it.
That's
I saw a guy just recently had a judgment from 2004, and the original judgment amount was about $4,800. The debt collector was seeking over $60,000 at this point because it had been churning interest at 30% for, decades now. And then that does lead to a bankruptcy. I
Well,
mean,
John, what happens with, I mean, I thought there was a statute of limitations on collecting of debt. That's not the case? Because
I don't
I mean, I thought after X number of years, they can't collect it. How's this guy get years and years?
yeah.
Or I guess it depends on the state, huh?
Well, and I can tell you that's one of the most commonly misunderstood parts of the law. So statute of limitations deals with the amount of time the creditor has to actually file a lawsuit against you. So the account goes into default. Here in Arizona, it's 6 years. It varies from state to state. But so they're saying, okay, the credit card company has 6 years to file a lawsuit from the time when you stop making payments on it. It's different though. Once a judgment's entered, if it's a default judgment or if it goes to trial, then there's a whole new set of statutes that apply.
Got it.
And like I said, in each state, it's a little bit different. In Arizona, those civil judgments are good for 10 years. But the kicker is they can be renewed every 10 years for an
That is
additional
nuts.
decade over and over and over.
I learn something more every time I record one of these videos. Okay, another thing I want to point out. So we're talking unsecured debt, and I just want to take this to the beginning. So someone gets a credit card, they spend $5,000 on it, they get in a car accident, they lose a job, and all of a sudden they go upside down and they can't pay it, right?
Yeah.
So it's an unsecured credit card debt. The people have no resource, and then the collection calls start coming. And they are coming and they come like a vengeance. So we've all received those, right?
Yeah.
And then it reaches a point where they actually sue you. And that's what we're talking about, right? So, and what they're trying to do is make a unsecured debt secured with the default judgment or some type of lawsuit. And you're saying 95% of those don't get responded to, which turn into a secured, like, all of a sudden that unsecured loan became secured with the default judgment, right?
Yeah, so 95% don't respond to it. So typically how the lawsuits work is process server comes by, knocks on your door, hands you a copy of the lawsuit. Then you have a period of time to respond to it. Here in Arizona, it's 20 days. In some states, it's 30. Some states, it's short as like 14. But if you don't respond, the court will just enter a judgment. Essentially, okay, assuming that what they're alleging is true, the courts don't even really do a whole lot of inquiry into it. They just sign off on it. And then once they have that judgment, they then have the power to take stuff. That's where they can start inflicting some financial pain in the form of liens, in the form of wage garnishment, in the form of bank levies. That's typically where we see creditors as far as the action they take. It doesn't show up on your credit report anymore, which is interesting. Back in 2017, the big three credit reporting agencies, TransUnion, Experian, Equifax, they changed the rules, and judgments do not show up on your public records section of your credit report anymore. But it all goes back to that 95% of people don't respond.
Right.
And I do see a lot of different reasons why that is. A lot of people don't know what to do.
Yeah, right.
They don't know. A lot of people, frankly, get served incorrectly. They get served at an old address or the wrong person. I see that frequently.
So let's unpack each of those actually. But one thing about the credit report, the judgments aren't shown, but the charge off and the collections leading to it
Yeah.
are shown, because we get that question all the time. Hey, I thought this wasn't supposed to be shown.
Yeah.
Well, the judgment, but not what led to it, like all the late payments, et cetera, et cetera. But that's easy. Raising your credit score is easy, even with negative things on your credit report. So let's talk about that. Someone gets served. Let's just pretend in this case they got served and they were actually served. You open it up. The first thing to do is you got to make a response or something, right? Or what would you recommend? I don't want to put words in your mouth.
Yeah. No, the first thing I tell people, when they drop it off is get your phone out, look at the summons, see exactly how many days you have to respond to it. It'll say it right there on the first page, and put it in your phone. Put that, make sure that that's that you have a reminder as far as when you need to file it. Routinely in my practice, I get people who call in and say, "Hey, I got served." And I say, "Well, when did it happen?" They say, "I don't know, 7 days ago, 10 days ago." In the legal system, the deadlines are they're deadlines. They're serious as a heart attack on those things. You got to respond. And so, and it's tough, admittedly. I mean, process server comes over your house. It feels really invasive.
Yeah.
I mean, you have a creditor, all of a sudden they're not just calling you on the phone. You have someone knocking on your door. And not only that, process servers, they always come at weird times. They want to catch you home. So I always, I look at the affidavit of service that they have to fill out. They often come by Sunday mornings at 7 a.m. or, a Friday night at 9 p.m., something like that, where
Yeah.
they'll show up, drop that off. But you got to write down the date that you got served, look at how much time you have to file the response, and then kind of put a plan together from there. Are you going to hire an attorney? Are you going to look at a bankruptcy option? Just because a bankruptcy, I mean, the thing that with the bankruptcy, we file the case, it stops the lawsuit, even right from the get-go. It'll stop it. But you got to start putting together your plan, and you have a very limited amount of time, to actually to get that done.
So before we go to the next, those steps, what if they served at the wrong address? Isn't serving meaning, don't you have to serve it? Don't they have to hand it to the person, or is that not considered serving? You just can't post it on the door, right? Or
Well,
misunderstanding that.
no, I mean, so the rules say that services, they have to serve you or someone of suitable age and discretion who lives in your home with you.
Okay.
Um, and there's some gray area there, Is serving my 13-year-old kid at home, is that service?
Yeah.
I would hope not, but the courts have said it is. Can they serve someone who's just visiting your home for the night?
Oh my God.
The rules say no, they can't.
Okay.
Here's what I see online a lot, over at, on my YouTube channel, is that people say, just avoid service. If they're coming by, don't answer the door, and that's how you beat these things.
Mhm.
I always say it's a bad idea, and I always get beat up online when I say this, because if you don't accept service, if you're avoiding it intentionally, the creditor can often go back to the judge and say, "Judge, we've been by 6 times. We know this person's home. They're just not answering the door." We want permission to do an alternative way of service. And in the old days, they used to have them put it in the classified section of some random newspaper somewhere.
Oh,
Since newspapers largely don't exist anymore, it's gone to email if they have it. Sometimes they will tape it to the door.
mm.
A lot of times it's just mailing it to the last known address, which is problematic because a lot of times people have moved.
Yeah, totally.
Um, so what I see is that people who tend to avoid service, they often end up with default judgments because many times they're not even aware they got
Right.
served. And so it kind of goes back to where we start with all this. Whether it's fighting the lawsuit, filing bankruptcy, taking action is really the key to it. You can't just let it sit there because that's going to cause you some problems.
So I'm not going to go down the road of like if someone wasn't served, et cetera, because that's a whole nother video. Let's talk about someone is served. They know they're served. They look at their phone. They put on the calendar when they need to respond by. I mean, when do you hire an attorney? When do you not hire an attorney? Obviously, people can do this by themselves, but like, I mean, there's a lot of rabbit holes here. So, well, I mean, first of all, they could talk to someone like you or a debt type attorney for free to get options, right? I mean, that's the first thing that's free. But like, what's the next step from here? If they know they're served, they got the date, they're out 20 days. What's the step?
I always give clients three options. When they get served with a lawsuit, I say, look, you can fight it, you can settle it, or you can file bankruptcy. Those are really I think good kind of buckets to think about. Okay, we can fight it. Is it something that we should contest? Is it something where we have defenses? A lot of it depends on who's suing you. Was it the original creditor? Is Bank of America, have they filed the lawsuit against you, or was the debt sold to a third party junk debt buyer? Is
Okay.
Midland Funding suing you? There's different defenses. If it's with the debt buyer, it's much more defense. There's a lot more defenses you can raise as opposed to if Bank of America sues me, they're gonna have the documents, they're gonna have the witnesses, they're gonna win their case unless you have some kind of, like, identity theft issue.
Okay.
So, we look to see, 1, who's filing the lawsuit, and that helps us determine should you actually fight it.
Mhm.
2, you can settle it, you could offer some type of lower balance payment plan, something like that to try to get it resolved. The 3rd option is bankruptcy, and when I'm talking to a client, I say, "Look, okay, you got this lawsuit. Let's talk about the bigger picture. If we win this lawsuit, are 4 more gonna take its place? Or are we dealing with a kind of a more global problem? There are a lot of more debt issues out there, because if it is, your money's gonna be better spent looking at a bankruptcy option that just stops the lawsuit and wipes out all these debts completely,
Right.
rather than trying to kind of piecemeal deal with these things. Because and we can maybe go into it or this or another video, but, the bankruptcy option is scary to a lot of people.
Yeah.
But truthfully, the recovery of that and the ability to deal with debt is much more efficient than trying to fight, 6 different lawsuits that are just piling on kind of
Yeah.
thing.
No doubt about it. So with regard to fighting it, so I mean, fighting it, you have to, I mean, if you're fighting it, that's one, it's the debt's not mine. That's why you're talking identity theft, right? But
Correct.
other than that, like, what's the fight? Am I missing something?
Yeah, I mean, generally, where we will contest it is if it's a junk debt buyer lawsuit. If it's been sold to a third party.
So
Oh,
like a Midland, right?
correct. And if you wanna go down a rabbit hole, kinda look at kind of research the whole debt buying industry. There's a great book called Bad Paper that I read a long time ago that talks about this whole industry of how debts are bought and sold, um, especially the large debt buyers, Encore Capital, Midland, Resurgent, Unifund. They sell at such a huge volume. Surprisingly, they don't get a whole lot of information. They don't. They usually get some spreadsheets with some names and phone numbers and that. And the reason why it kind of goes back to where we started. 95% of people don't respond, and so the debt buyers rarely required to show a lot of proof. They're just minimal documentation. And what we have found is that, one, I mean, if a debt buyer sues you, not only do they have to prove that you had the account with the original creditor, they have to prove you breached it, what the terms were, what the balance owed is. They have this added step of showing that they're the actual owner of it. And it sounds crazy, but a lot of them struggle to do that, particularly if it's been transferred multiple times.
Yeah.
When they get into a courtroom setting, the rules of evidence, the rules of procedure, they've got to actually come in and establish that, and they struggle to do it. So a lot of times you can defend the case on that, or at least position it so you can get a much better settlement overall, compared to an original creditor case where you're not going to have those defenses.
Got it.
I always tell clients, you got to settle that or file bankruptcy on it. Those are really your options.
Okay, and then so the second thing is the settling. So when we're talking settling debt, what are we talking settling for? So if let's just pretend it was the first party creditor, Bank of America.
Yeah.
Obviously, they're going to settle different than a Midland, right? So ballpark? I realize it changes on all these different levels, but like a Bank of America first party creditor, are we talking 50%, 40%, 60%? What are we talking on a settlement?
With an original creditor like that, you're looking at probably 40 to 60% before the judgment is entered. Once the judgment entered, I always say there's these scales that we're dealing with where as soon as then a little more power shifts to the creditor because now they have a judgment, they can come in and wreak havoc in your life. And so, if they have a judgment or if they're like, if let's say they have a wage garnishment that's pending,
Mhm.
sometimes people come to me and say, "Hey, I just got hit with a wage garnishment and I want to settle this."
Yeah, right.
Yeah, at that point, it gets pretty hard. The creditor says, "We have a settlement, and it's called we're gonna take 10 to 25% of your check every 2 weeks."
Every single pay period.
Yeah.
Yeah.
And so, the one thing you can do, and sometimes I say it's actually a blessing in disguise to get hit with a lawsuit if you're trying to settle, because you can agree to a payment plan through what's called a stipulated judgment, or sometimes we call them pocket judgments, where you can say, "Hey, plaintiff, hey, creditor, I can't pay you a lump sum. I don't have it, but I can pay 80% of that balance. I'll pay $300 a month, and I'll back it up with a judgment where both parties sign off on it. And there's a couple terms in there that are important. One is there's what's called a covenant not to execute or a covenant not to collect. They're not going to do any collections against you if you're making those payments each month. However, to the benefit of the creditor, if you don't pay them, they get an immediate judgment for the full balance that they can immediately come and try to garnish your pay or lien your home or whatever. So it gives them a little bit of security. They're getting voluntary payments from you. You can,
Right.
I mean, I've had American Express stretch it out over 8 years before
Right.
on large balances. And so there's a lot more flexibility that you can do that sometimes you don't have, frankly, before the lawsuit's filed.
Okay, so that now what about settling on like a Midland? If we did get a Midland,
Yeah.
could those be settled for more? Like not 40 to 60? Could they be lower?
Yeah, a lot of that'll we routinely settle those for around 25 to 30%. Um, I can tell you the threat of litigation, sometimes, if we're gonna continue on with the lawsuit, that could be, kind of a part of it. I also say you gotta look at kind of from the creditor's perspective, how difficult is it gonna be for them to collect on this?
Yeah.
Is it something where your pay is Social Security, you don't own a home?
They're uncapped.
Um
I mean, who's
Yeah.
yeah,
We
exactly.
we we call it being judgment proof.
Yeah,
Is it something where, they could get their judgment, but good luck, they're not ever gonna collect anything? You can use those facts to get a lower settlement, and if it's a debt buyer, Midland Funding, there was an FTC report that said Midland Funding pays on average 4 cents on the dollar for their debt. So, they don't have as much invested into it,
yeah.
It's something where they want the full balance, but they'll take considerably less, especially if you press them and if you can provide some hardship information of, "Look, I don't have a job or my money's exempt, it's protected, it's VA disability or Social
Right.
Security, I don't have a home to lien," all that kind of stuff can lead to a much lower settlement.
So let's unpack this. Let's pretend you have a lawsuit that has equal with fees and all that stuff, $10,000, right? So the first thing is to fight it. And if they fight it, I can't imagine these people fighting it on their own. I mean, do you think how often do people fight these things on their own as opposed to hiring an attorney?
The stats are so 95% in a default. Of the 5% that contest at less than 1% hire an attorney. And usually what I see is usually out of necessity, and I get it, I always say I don't want to make a tough situation worse by throwing a bunch of lawyer fees at it. And surprisingly, a lot of these lawsuits are under 10,000 and even under $5,000.
Okay, got it.
I've actually seen creditors say they're more willing to file lawsuits on small amounts rather than the $50,000 credit card, just because they know if you get sued for 50 grand, most people just file bankruptcy. Um, but it's something where if you're getting sued for these smaller amounts, the factors that go into settlement, again, you just need to, you file the answer. Filing an answer, I say, even if you do that on your own, um, it's going to, one, buy you some time, and two, in 30 days, they have to provide you all their documents. And so you can kind of look through and determine, is there any angle that we can take to
Okay.
put
So
up
the
a
good
proper
so the
defense?
natural first step is just respond,
Mhm.
and it doesn't have to be formal. It can be a yellow pad that type it up or whatever, or go to ChatGPT and say, "Respond to this lawsuit," and just submit it.
Yeah.
Like, that's really the first step, right?
Yeah. The answer that you're filing to it's the most simple part of the lawsuit. And one, it helps you avoid a default. And two, it buys you a lot of time. It'll buy you a few months usually before really anything significant is going to happen. And the answer, all the court wants to know, I can tell you the number one mistake I see when people draft their own answer. They put too much information in there. They try to put in there why they, fell behind, why it went into default, or they may even start putting settlement proposals.
Mhm.
I would say not necessary and actually can be detrimental to you.
Yeah.
All the court wants to know is, hey, here's these numbered paragraphs that the plaintiff has filed in their complaint. They want to know, do you admit or deny what it is that they're alleging? They basically want to know, do we have a dispute here, or does everybody just agree on everything?
Yeah, right.
And I would say, you got to be honest. You got to be truthful when you're submitting things to the court. I also say you've got to be painfully truthful. If they're claiming that $9,862 is owed, unless you have an independent knowledge that number is exactly right, it's okay to say, I don't have enough information right now, so I'm going to deny at this point, things like that.
Okay.
Um, so kind of just responding directly to it, submitting it to the court, that'll buy you quite a bit of time to decide, okay, is this something I want to contest? Do I want to settle it? Have I got a lot of debt? Do I need to go the bankruptcy route? Those kind of things.
So the second I was settling, if it's like a Bank of America on a $10,000 lawsuit, they're gonna pay $4,000 to $6,000 just to settle it, right? That's not including any other lawsuits that are coming down the pipe. I mean, what we've seen over and over, and you've seen it too, I've seen it over and over, where, okay, here's one credit card for $5,000 or $10,000, you alluded to it earlier. And by the way, here's another one. Oh, here's a payday loan. Here's this thing that's coming down the pipe. May not be in lawsuit stage, but all this medical debt that's like weighing the clients down, right?
Yeah. Yeah.
So when you're looking at that, then 10,000, okay, I'm going to settle for 4 to 6,000. Add in all this other debt as well, right? Because that's where bankruptcy becomes, wow, this is reasonable, because it's, as you called it, I like that, the nuclear option. It wipes everything out. The lawsuit stops, all the medical debt, the payday loans, all these other credit cards, like like it wipes it out depending on the type of bankruptcy, your income, et cetera, et cetera. Let's go into that a little bit as we wrap this up.
Yeah. No, and I agree that, because one of the things, one of the biggest misunderstandings I see in the online world is the charge off. Some people think, okay, I hit by this lawsuit, I don't need to worry about anything else because they've all been charged off.
Yeah.
Charge off is just an internal tax reporting that a company does. They absolutely can still sue you. I get a lot of hate comments every time I say that on my YouTube channel. They could absolutely still sue you. They can still do collections. The charge off doesn't have anything to do with whether. And so there may be a ton of other debt out there that you need to deal with. And so that's when I say, let's maybe look at like Chapter 7 bankruptcy. Chapter 7 bankruptcy, you do have to qualify for it based upon the number of people in your home, your income. Most people can qualify for it. Overwhelmingly, most cases are Chapter 7. It eliminates the credit cards. It eliminates the personal loans, medical bills. In most situations, people can still keep their house, keep their cars, keep their household goods, keep their retirement accounts. And so it's something that's good to meet with an attorney and kind of walk through that. And people will tell me that all the time, hey, when we walk through the process, they're like, that's not as bad as I thought it was going to be. We always go to this dark place where we think, if I do the bankruptcy, I'll never have credit again. I'll never buy a house. And that's absolutely not true.
Yeah,
And
that's right.
actually, the surprising thing that I see is it's often the people that try to just kind of drag these things out, deal with them one at a time. They turn around and they've been doing it for 10 years and the bankruptcy would have resolved everything,
Yeah.
a decade ago, and they would have moved on. So, I think that's kind of, it's hard to do, but kind of maybe looking at the bigger picture overall of what your debt situation is and how a bankruptcy, like I say, nobody wants to go there, but it may be the best overall option to just deal with everything quickly and for much less than you're going to pay. Even if you hire a bankruptcy lawyer, it'll be much less than what you pay trying to settle or fight these things out.
Well, and plus, a bankruptcy attorney will talk to you for free. right? I
Yeah.
mean, on your channel, there's a link to you and all these our bankruptcy attorneys in our network. You know, I host a live question and answer session for clients that go through Evergreen Financial Counseling, a nonprofit, on how to improve your credit score after financial meltdown. And we have all these people who join the calls. And a lot of people, where do you talk about your bad credit and your bankruptcy and your foreclosures and your debt settlement? You don't talk about it at dinner parties. You talk about it on calls like this with other people that have the same problem.
Yeah.
And we hear these people who are um, on the call and they're like, gosh, I filed bankruptcy. My credit score is 720 a year later. I just bought this car, all this stuff, rebuilding their life. And the people who were enrolled with debt validation companies, debt settlement companies, debt consolidation companies. I had one client on the call and it was really just, I didn't know what to say. He's like, well, I'm hearing all these people just filed bankruptcy. Like, why am I paying this company $300 a month? I've been paying them for 2 years. And it was just like, they just don't understand. And the first step is to get facts.
Yeah.
If you're considering debt consolidation or debt settlement or whatever, okay, get the facts. Look at the facts of bankruptcy, and just that way you can make a decision what's best for you and your family.
Yeah. And that's what, and frankly, that's why I started my YouTube channel. Like I said, because I would talk to people all the time. And I mean, literally daily, people were telling me, am I going to go to jail? Because I didn't pay my credit card. And, I'm like, debtors' prisons, they went away in 1840s, but
Yeah.
that mentality is still there, that people they feel bad about it, they're ashamed about it, they're worried what's gonna happen. But if you get the facts, you can realize, hey, there's some paths forward here. Even if it's a bankruptcy option, I mean, there's a path forward there that's gonna be pretty straightforward, not as painful as you're thinking, and you're gonna recover from it. My clients are always shocked to see we filed Chapter 7, and literally within weeks, their mailbox is full of credit card applications and car loan advertisements. I mean,
It's
I
shocking.
always say it's a little bit, yeah, yeah. I always think it's a little perverse the credit lenders do that, but
Yeah.
they do it. And it's those things. I have clients in Chapter 13 cases. I had 2 clients last year who bought homes while in the bankruptcy.
Yeah.
And so
Yeah.
I don't sugarcoat it. There's obviously consequences to it. But if you're dealing with just overwhelming debt, if it's not just a one-off thing that,
Yeah.
that's why I started defending debt collection lawsuits, because I did run into people who the credit was generally good, but there was 1, maybe 2 creditors that were causing problems. I'm like, let's don't file bankruptcy. Let's just kind of deal with this $4,000 lawsuit and be done with it. But if you've been maintaining a huge debt load for a long time and it's just years and years and you're not making progress, I think it's worth looking into.
John Skiba, Mr. Consumer Warrior. John, thanks for all this information, valuable information, and we'll see you soon.
All right. Appreciate it, Philip.
Hey, John.